crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Good evening and welcome into the attorneys. Appreciate you being with us tonight. Got an interesting conversation. If you are a business owner, have a friend who is a business owner, or even has entrepreneurial dreams, give them a call. Let them know that tonight is a show that they're just going to love. A lot of great and helpful information is on the way. You'll meet the panel of experts coming up in just a bit. First, though, want to remind you of a couple of kind of the ground rules of how the attorneys works each and every Sunday night. We've got ways you can join our conversation. That information at the bottom of your screen all throughout the show tonight. So please join us in that conversation. And Hollis Wright makes available attorneys from the firm who are standing by live. It's a free, off-air, and confidential conversation between you and an actual attorney from Hollis Wright. So take advantage of that opportunity. Again, it will be yours for the taking all throughout tonight's program. Leading our conversation is Managing Director of Hollis Wright, Josh Wright. Good to see you, sir.
Great to see you, too, and I hope you had a great week. And, you know, one of the things I like to make sure that people know is when you say that you can call, text, email, and there's a lawyer standing by, that's not fluff. That's real. Yeah. We've got lawyers standing by right now to answer questions associated with this topic or other topics that people may be facing. The concept of this show from the start, David, many, many years ago, was to make sure that we help people address legal issues they face in the real world on a weekly basis. And that doesn't always mean it relates to business disputes. It may relate to a personal injury case, right, whatever it is, or a probate issue. We're going to be here to be able to help lead, guide, and direct people through it. But tonight, we're focusing on something, which is business disputes. And Todd Campbell, who comes from a pedigree of lawyers in his family, is here tonight to talk a little bit about business disputes. This is one of the things that he does as a practicing lawyer. And we're going to be talking about what happens in circumstances where you've got a dispute with your business partner, or you have to file suit from a business perspective, and maybe you got to arbitrate a claim. How does that get managed and handled? So we're excited to have Todd on tonight. Welcome.
Thank you,
First time on the show, right?
That's right.
All right.
First time on.
Well, good. We're
Thanks
glad
for
to have
having
you
me.
on. Tell us just, first of all, I know before we started, I asked you a little bit about your practice. Tell us a little bit about your practice and kind of who you practice with and just kind of what y'all's focus is.
Yeah, we have a small firm, Campbell Partners, located here downtown. It's about 7 of us. It's a boutique litigation firm where we pretty much handle all litigation in the business realm, commercial, complex business litigation. And we have about 7 attorneys there, and we're light. We practice a lot in state and federal court and also in arbitration. So it's a good practice.
So people ask me a lot of times, oh, so you're one of those lawyers that does suits related to, you know, if a business that gets in a dispute with someone else. I'm like, well, that we don't really generally do that, but we get you to someone like that. There's a difference in litigation, right? Like
Right.
What I do is more on the personal injury side. Right. You're handling a lot of claims where a business comes to you because they've got a dispute either with a business partner or another business, or they're in business and they're struggling with a vendor or contractor or something like that.
That's right. A lot of what we see these days is disputes between shareholders in a closely held business. So 2 to 3 shareholders in a small business, and they have a falling out. And essentially the majority shareholder is trying to deprive the minority shareholder of their reasonable expectations in being a business owner. So for example, what you see is the majority shareholder or the controlling majority group has a falling out with the minority shareholder, and then they take some kind of punitive action against the minority shareholder, such as terminating them from employment, terminating them from management, cutting off their salary, their income, their distributions, cutting off their right to participate in management of the company. And so you have a minority shareholder who essentially has been cut out of their interest in this company, and they have generally there's restrictions on transfer of those interests in these closely held businesses. So you have no market to sell your interest, and so you're essentially sitting there with receiving no benefit from this. And generally, it takes filing suit. Sometimes you can negotiate it prior to filing suit, but generally you have to file suit in order to protect that interest, and you assert oppression claims as well as other claims. And
you're good. It happens to me all the time, actually. That's probably a client calling.
I hope so.
Sorry to get in the way.
That's right. So essentially, you file suit. Many times these cases end in a settlement, which involves a buyout of the minority shareholder's interest.
So how did you, this is kind of a unique area of the law that not every lawyer is capable of doing and understanding. It's a complicated area of the law.
Yep.
How did you get into this?
Well, we've been doing it since I started practicing. I've been practicing about 10 years now. Our managing partner, Andy Campbell, has been doing it for years. Wrote a number of articles on minority shareholder oppression, and it's not that well of a developed area of the law in Alabama. You have to look at other states a lot of times. Delaware, for example, has a lot of authority on it. But there is a niche here. Not many attorneys in Alabama do it, and so we pride ourselves on being knowledgeable and being experts in this area of the law.
Dave, you think that because of the number of shows we do related to probate-related issues or personal injury-related issues, wills and estates, that we're always dealing with individuals, the number of businesses in Alabama would stagger you.
Yeah.
I mean, just to think about how many small mom-and-pop businesses to large corporations there are in Alabama. And a lot of these businesses run into issues a lot and have to have an expert that knows what they're doing to lead, guide, and direct them through it. And Todd's firm is a good example of that.
I'm curious how post-pandemic and all that did to businesses, how did that change the kinds of cases that you all had?
Honestly, we haven't seen that much of a change. We've seen the same kind of frequency of this litigation, even during the pandemic. People, small business owners are still fighting.
Right.
But one new component, as you see in the cases, is disputes over the PPP loan money, and whether that's paid back or whether that was used appropriately. So that's kind of a new factor you see. But in terms of frequency, in terms of people fighting and need to litigate in this area, it's been about the same.
I would imagine, and I agree with what Todd is saying from what we've seen from our perspective too on our side of the bar, but I would imagine that there are more financial strains post-COVID with business partners than there probably has been for many, many years. Hopefully people are coming out of that, but post-COVID, it was a difficult time for people to get back their feet underneath them and be able to move forward. I know we're getting ready to go to break. When we come back, I want to talk a little bit about how the arbitration process has been used in contracts and in partnership agreements to be able to manage some of these disputes outside of having to be in front of a judge and jury, but instead being in front of an arbitrator, because I know it's something Todd deals with on a daily basis.
All right, that's a good spot for us to step aside our first break of the evening. Hollis Wright does a number of things well, but they also do social media well. So if you're on Twitter or Facebook, Instagram, YouTube, you can find them there. Just search the term Hollis Wright and you will find them, easy to find there on wherever you are on social media. Hollis Wright is probably there as well. Stay tuned. We're coming right back.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with the attorneys.
Welcome back. Appreciate you being with us tonight. Before we head back into this conversation, just want a real quick reminder that those attorneys from Hollis Wright are standing by live throughout the program tonight. So as long as we're on the air, they are standing by, which means the clock is ticking. So if you want to take advantage of that opportunity to speak with an actual attorney from Hollis Wright, then go ahead and give them a call. They're standing by and waiting for you. Josh?
Yeah, Todd, talk to us just a little bit about this issue of arbitration and the way a lot of these claims are litigated. I know there's plenty of claims that you deal with on the business side that are litigated inside a courtroom, but arbitration really has streamlined the business-on-business dispute world over the years. So I'm assuming that's kind of a pretty big issue that you guys face.
Yeah, generally where you litigate these types of cases depends on the governing documents, the operating agreement or the shareholders agreement, what you sign to govern the parties' relationship. So you look at that. If it doesn't contain a mandatory arbitration clause, then you're free to file it in court. If it does, which a lot of them do, you have to file it in arbitration. Most of those clauses contain a arbitration provision requiring you file it in AAA, the American Arbitration Association, that handles arbitration disputes. So arbitration is a little different than litigating in court. It's more streamlined, like you said. Generally, it's more cost efficient. There's less discovery involved, less depositions being taken. Evidentiary rules are more lax, and it's generally quicker to get to a final hearing and get a decision made. The other thing about it is you try it in front of one arbitrator or a panel of 3 arbitrators as opposed to a judge or jury, and they decide your case. And they generally have a time deadline by which they have to render an award, and you don't have a right of appeal in most situations. So you get some finality out of it, ends the dispute, it gets over quicker, and so many times we're in arbitration and we're comfortable litigating there as well.
Yeah, you talked a little bit about a lot of times you'll have a majority shareholder, there's a falling out with the minority shareholders. Or members of that organization. Do you mediate a lot of those before you have to file? Are there ways that you guys can get involved to help litigate those cases without actually filing the suits to resolve them? Yeah,
a lot of times you can negotiate them pre-suit, whether it's through a mediator or informally negotiating. But generally, it behooves the majority shareholder to go ahead and do that on the front end instead of spending a bunch of money litigating the case. It's worth it to maybe pay a premium to get the minority shareholder out, get that finality, and move on with your life so you don't spend 2 years litigating the case.
Guess what is the most important component? I know that Todd will tell us this. The most important component that will help the minority and majority shareholder if there is a dispute. What do you think you have to do on the front end? Have an operating agreement. Operating agreements, because you go to someone like Todd on the front end about setting up a business correctly. He does more of the dispute side, but they set up businesses too and get involved in that process to make sure that the documentation is properly set up, that outlines the responsibilities of the various parties. And we do shows on this. We've done many shows on how do you set up a business correctly. If you set a business up correctly, what you find out is you can limit some of the disputes on the back end because it's spelled out what responsibilities and obligations various members of the organization have from the start.
What are the most common mistakes people make? Maybe folks who are thinking of going into business. Let's try to help them avoid the dumpster fire here, okay?
Right.
With a partner dispute or a lease with a landlord. What are the most common mistakes that you see people making on the front end that if they had just not done this, their position would be so much greater and beneficial to them?
Like Josh said, not having an operating agreement or governing agreement, governing the relationship. You don't have anything that directs you what to do there. You have no specificity of what happens in this type of situation.
Now, do folks do that because they're going into business with a family member and they just trust that it's all going to work out fine? Like, why do folks not have that?
Yeah, well, a family member, a lot of times we do see these disputes between family members.
Right.
Or other times it's just they don't have time or they trust the person or they just don't want to hire an attorney on the front end to do it and spend that money. But that is one of the huge issues, and also a poorly written operating agreement presents issues as well, where it's vague or ambiguous or doesn't address a certain situation. That causes problems too, because you have to get the court or the arbitrator to interpret it.
And I'd mention kind of 2 points related to that. One is, I think you ask a really important question, and that is, why would someone go into business with another person without having proper documentation, having a blueprint and a roadmap and an operating agreement to make sure that it spells out what everyone's obligations are? A lot of times people are super aligned, and Todd probably has seen this in his practice. They're super aligned when they've got a common vision of, hey, we can produce this product, or we can manage this, or we can be a vendor for this company. We can provide. Things are great with the vision. The problem is the vision doesn't always get executed perfectly. Sometimes it is executed in a really positive way where there's a lot of money at stake, and all of a sudden now there's a dispute as to, well, hold on, who was bringing cash into the deal versus who was bringing sweat equity into the deal. We should have decided that on the front end, and sometimes things don't go well, and the relationship sours, and that's when you've got to be able to fall back on an operating agreement. The one piece of advice that I can give, just running a business as long as I have, is that you have to have consistent times where you reevaluate your operating agreement to assess changes in circumstance, whether it's hiring new partners, whether it's increasing equity percentages in partners, whether it's taking on additional debt, whether it's having a new business stream and a new way for your business to try and make money. You've got to reevaluate those operating agreements to make sure that they are keeping pace with the changes in your business itself. And I'm sure you see that on a weekly basis.
Yeah, that's right. We do see that a lot, and like you said, we do non-litigation corporate formation work, and so we see a lot of these small business owners coming to us with changed circumstances, or they want to add a partner in, and it's best to document that with a amended operating agreement or some kind of formal document showing that change.
I know we're getting ready to go to break. When we come back, I want to talk a little bit about what Todd sees most often. He talked a little bit about some of the majority shareholders, but I want to talk about some other sides of his business. I also want to talk about what to do if you're sitting on the couch right now saying, man, I don't want to fire up my majority shareholder, but I've got some problems that need to be worked out. I need a lawyer to walk me through this.
Right.
What is a next step, and how do you go retain someone to work through that? Because there's a political angle to this too that Todd has to manage on a daily basis.
Yeah, that's good stuff. We're going to pick that up. We're stepping aside. Our final break of the evening. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis, Wright. In court, attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 4-in-1, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Now, Rule 403 of the Alabama Rules of Evidence states, in part, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule and is to be excluded. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is wealthy or rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there's sufficient insurance coverage or assets to satisfy a verdict. Most likely, the parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during trial, there likely are resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. And remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. And as always, thanks for watching The Attorneys right here on WVTN 13.
Welcome back. This is the final segment of The Attorneys. So we have about 6 minutes remaining in our program tonight. Now, what that means to you is that if you want to speak to those attorneys from Hollis Wright, they're standing by, but only for another 6 minutes. So take advantage of that opportunity. Just a few minutes to do so. Josh?
All right, so Todd, let's talk a little bit about next steps for someone who may be sitting on the couch or watching this show on YouTube after the show airs, and I have an issue. There's a political side to this because I don't want to create division among our members in this organization, but I've got some issues that I need help with. What's the next step for that person?
Yeah, I think the next step there is see if you can talk with your co-owner in the business. See if you can work out what your issues are between the two of you and document it in writing, whether through a amended operating agreement or a board meeting with minutes or a consent in lieu of a board meeting. That kind of thing can go a long way. When you pull an attorney in, that's when things can get adversarial. But you can come to us or an attorney that handles this kind of stuff, and we can give you guidance behind the scene where you can go and approach the majority shareholder or your co-owner to talk through sensibly the issues here. We can look at the documents, the governing agreements, interpret those, give you advice on them. We can look at the financial records to see how the business is doing, advise you on that, and what course of action you need to take. And if they still won't discuss it with you or change their ways, then the attorneys can get involved at that point and try and negotiate whatever solution you're looking for.
You know, a lot of times I think people hear this concept that you can have a confidential conversation with an attorney. They don't recognize the obligations that we have as lawyers. When we decided to become lawyers, that confidentiality matters. When someone says, I need this to be held confidential, that doesn't mean it goes back to your spouse or your children or your family. That is confidential. So what Todd's outlining is a really important process, which is hey, someone's sitting on the couch saying, there's a political side to this. I don't want to fire up our members, but man, I need advice. Like, what do I do? How can I encourage my majority shareholder without a lawyer getting involved to do some things that I think should change in the business? And Todd is exactly right that sometimes you just want someone to give you advice, even though you're not going to disclose you're talking with a lawyer, so you know how to start moving maybe a majority shareholder or a minority shareholder in the right direction.
And having a sounding board like Todd, someone who really operates only in this area, I mean, imagine all the scenarios and all the potholes you could avoid.
Yeah, and you know, Todd, one of the questions I also wanted just to ask is, you talked a little bit about the majority shareholder. You know, what do you see? I mean, we see, for example, on our side, just running our business, you know, we sometimes will have disputes with vendors over what they provided or didn't provide pursuant to our contracts.
Yep.
You know, we don't get into litigation over all those, but a lot of times we've got counsel on hold that we can just go to and say, hey, how do we manage this? What advice do you give us? What do you see? I mean, is it in the contract world that you see people not complying with what they're supposed to be doing? I mean, what is it?
Yeah, I mean, it's offshoots of what I've been talking about, whether it's a breach of contract where they fire an executive wrongfully, and we're trying to negotiate what they should be paid under that contract, or you see a partner leave and that person gets threatened or sued with restrictive covenants, meaning non-competes or non-solicitations, and you have to work through those issues because generally that person that leaves wants to start their own business. So we have to advise those people on how to protect themselves, and sometimes we have to defend them as well if they get threatened or sued for breach of their restrictive covenant. So it all comes down to the contract.
Yeah. You know, we see that a lot, David, and there are ways that you can work through it. I mean, think about it from a law firm, Todd's law firm too, perspective. I mean, the retention of experts, how our landlord and how all that's managed at our law firm, business relationships, our banking relationships, all those things require advice at times. And so it's always good if you've got a business to be able to have someone on standby. Todd and his firm are a great example of that. If you forget Todd's name, you call us. Right. We're on every Sunday night. We'll get you to Todd. Yeah. And that's an easy push to him.
Real quick, Todd, 20, 30 seconds from you, just a final thought for our viewers.
Yeah, get advice from an attorney on the front end before you go into business. Get them to review the documents. Make sure you have a contract laying out all the specific and important provisions, and get an attorney to look at that before you ever go into business. That can save a lot of trouble and expense down the road.
Yeah, and I would concur with that. I think it's very important, David, when you have this vision with another person that ultimately is going to be your partner, that you've got a plan. And part of that plan is creating the right structure to start with, which Todd can advise you on, making sure you have the proper operating agreement, which Todd can advise you on, and then hopefully propelling your success because you've got the plan set up, which Todd can help you with. Right. And if there's a dispute at the end, guess what? Todd's firm can help you with it. And so that is why, you know, I think it's super important to have a relationship with someone like Todd's firm if you're going to start a business.
Absolutely.
Good job, man.
Fellas,
great job.
Thanks so much.
Glad to have you on.
Thank you joining us. Thank you joining us as well. Appreciate the time. We'll see you next week right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.